Hello, everyone, and welcome to the Feed Your Brain series. Today, we will explore the new right to disconnect legislation. My name is Paige Splain, and I'm the event specialist here at Workplace Safety North. We appreciate your attendance here today and want to let you know that this is our first Feed Your Brain webinar of 2022. Join us in 2 weeks for our 24th annual Mining Health and Safety Conference. WSN is offering this free virtual conference on Wednesday, April 27th from 9 a.m. until 2:30 p.m. Space is limited. Before we get started, we want to mention a few housekeeping items. During the webinar, you may see your screen freeze up or hear static on the microphone. This is usually temporary and due to internet connection issues. We appreciate your understanding and patience with the technology. Your microphones have been muted, and we ask that you use the Q&A at the bottom of your screen for speaker questions. If you have any technical issues using the Zoom application, do let us know in the chat box and we'll do our best to help you. So to clarify, please put any commentary in the chat box and speaker questions in the Q&A section. Resource information and a recording of the webinar will be sent to you within 1 business day. Now, I'd like to pass things over to host Elisha Malette, Health and Safety Specialist and Certified Psychological Health and Safety Advisor at Workplace Safety North. Welcome, Elisha.
Good morning, Paige. Thanks so much. As we prepped for today's session, I couldn't help but think about how so much of how our world has changed as a result of this global pandemic. But realistically, we can't really blame the global pandemic for all of our work-life balance challenges. They've existed long before, but as a result of the pandemic, it sort of sent a surge of people working from home and no longer had that clear expectations or 4 boundary walls that made the difference between where we are working and where we are not. So this topic of around the right to disconnect became an easy one to select for a Feed Your Brain webinar. Now, to get a better understanding of who's on the call and where some of your concerns might be, Paige has just put a poll question up on the screen for each of you to review. This will help us better understand what you might know about it, what you might not know about it, as well as some of the concerns you have. So I ask you just to go ahead and start to go through those poll questions, and then we'll take a look at them in a minute. While you're doing that, I thought I could take this time just to explain a little bit more about Workplace Safety North for those of you who are not familiar. Workplace Safety North is a partner in the health and safety system within Ontario, and we work with the natural resource sectors, including mining, forestry, paper printing, and converting. We have health and safety specialists across the province who deliver training, consulting, and events. Our goal really is to assist you in making your workplaces the safest that they can be. The vision for Workplace Safety North is that every worker can get home safe and healthy. And when you think about that statement, we're not just referring to physically healthy. We want everyone to be able to get home to their families at the end of the day with their mental and physical well-being intact. So I can see people still answering some of these questions here. So I look forward to seeing what some of the answers are going to be. To continue on as you're going through that, I would like to ask and just provide an overview of what we'll talk about today. The session itself has been divided into 3. So the first part will be a presentation provided by Valerie, who I'll introduce more formally in a little bit. And she'll provide the Ministry of Labor Training Skills Development side of the right to disconnect legislation. And then we'll have 2 bright legal minds join us, Alana and Robert, to give that sort of legal perspective into the right to disconnect. And we'll finish the session today with an opportunity to do a questions and answer period. Now, I see that the polls have been completed, and the very first question there really was one I was curious about, because even preparing for this session today, I felt like I probably sit with the majority of the group. I feel like I know a little bit and look forward to learning a whole lot more. And for those of you who don't know anything about it, I think I was right where you were as we were planning it. I took some time to dig in since then. And the one person on here who can tell us all about it, I suspect you might have some good questions for us along the way. When it comes to the nature of our workplaces, the type of scheduling, Very interesting. It's a good blend of everything. A lot of typical 9 to 5, 8-hour shifts, shift work, flexible work hours, remote work. It's pretty amazing how varied all of those work schedules are. Very good. And then the overtime on-call emergency response applies to the majority of the groups. So very interesting. Thank you for taking the time to do that poll. And I think it provides support for our speakers, presenters today to get a feel of what the audience would like to know more about. Perfect. Okay, so I was going to introduce our speakers more formally. So I'd like to introduce Valerie Henschel. She will be our first presenter today, and she has worked with the Ministry of Labor, Training and Skills Development as an employment standards officer since 2014, and she currently holds the role of Regional Program Coordinator. Valerie is a human resource professional and has completed her human resource management program at McMaster University. She holds the designation of Certified Human Resource Leader, as well as an executive certificate in conflict management from the University of Windsor. Since joining the Ministry of Labor, Training and Skills Development, Valerie has appreciated the opportunity to use her skills to serve the public interest with integrity, honesty, and commitment while administering the Employment Standards Act through claims resolutions and proactive workplace inspections. We also have Alana Heath, who has grown up in Timmins and is pleased to return home to provide legal services to her community. She obtained an undergraduate degree in political science at the University of Guelph and followed by a Juris Doctor degree from the Boris Laskin Faculty of Law at Lakehead University. During this time, she was Vice President External of the Law Student Society and the co-president of the Environmental Law Students Association. Alana is passionate about employment law and seeks to provide strategic and practical advice to clients within Northern Ontario. Alana is dedicated to high quality service and fostering strong working relationships. Last but not least is Robert Jones, and he's joined the Suzanne Delorier Professional Corporation and is originally from the Greater Toronto area. He completed his undergraduate studies in political science at the University of Toronto and obtained a Juris Doctor degree from the University of British Columbia. During law school, Robert received the David Roberts Prize in Legal Writing and served as a note taker for the Access and Diversity Office. Robert articles with a litigation firm in Toronto, and he values honesty, integrity, and professional development. He works hard to obtain the best results for his clients. So I think with our lineup today, we know we have a great group that we can rely on for good information. And I hope that each of you at the end will be able to move that needle a little bit more with how well you understand this right to disconnect legislation. So without further ado, I would like to welcome Valerie. And I look forward to hearing what Valerie has to contribute. Thank you so much for joining us today, Valerie.
Thank you, Elisha. I'll just wait one moment. Paige is going to put up my presentation and then we can get started. Okay, thank you, Paige. So thank you for that introduction, Elisha. As mentioned, I'm currently a Regional Program Coordinator with the Ministry of Labor and Training Skills Development. This morning, I will be presenting to you the employment standards requirements for a written policy on disconnecting from work. And Paige, can you forward? Thank you. So just some background information. The Ministry of Labor, Training and Skills Development administers and enforces the Employment Standards Act, as well as the Occupational Health and Safety Act and its regulations. And with respect to the Employment Standards Act, we provide compliance support. We conduct proactive inspections of payroll and other employment records and workplace practices to ensure that their employers are complying with the Employment Standards Act, and we investigate individual complaints. So today we have two objectives. First, to provide an overview of the written policy on disconnecting from work requirements under the Act, and to provide tools and/or resources to help you learn more about the Employment Standards Act in general. Next slide. So just a legal disclaimer, while we've prepared this presentation for employees and employers to understand some of the minimum rights and obligations established by the Act, it's not legal advice. It's not intended to replace the Employment Standards Act or regulations, and any time you need an update, you need to reference directly the legislation. We try to make sure we don't, that this presentation is as current and accurate as possible. However, sometimes errors do occur. The ESA itself provides minimum standards only. So some employees may have greater rights under their employment contract or collective agreement, under common law, or other legislation may apply. So employers and employees are always advised to obtain legal advice. Next slide, please. So the background of this legislation: on December 2nd, the Working for Workers Act 2021 received royal assent. Certain employers will be required to have a written policy in place for all employees with respect to disconnecting from work. Next slide, please. So disconnecting from work is defined as not engaging in work-related communications, which includes emails, telephone calls, video calls, sending and reviewing messages, so as to be free from the performance of your work. So what is considered work? The Act contains provisions that establish when work is considered to be performed or deemed to be performed under the Employment Standards Act. Generally, work is considered to be performed when the employee is actually working, or the employee is not working but is required to stay at the workplace or hold themselves out available for work at the workplace. The time spent by an employee carrying out the activities specified in the definition of disconnecting from work, so that's the emails, telephone calls, video calls, all count as work under the Employment Standards Act. Next slide, please. So transitional provisions, when requirement to have a written policy takes effect. So the first step, employers are to determine if they employ 25 or more employees on January 1st, 2022. So that's an important date. That's when you decide if you have, or determine if you have 25 employees. If that's the case, you move to step 2, which is to have a written policy on disconnecting from work by June 2nd, 2022. And then you provide a copy to your employees within 30 days of when the policy was prepared. So if it was prepared on June 2nd, then 30 days from June 2nd, you have to provide a copy to your employees. Or if you already had a policy and you've just made amendments and changes to it, you have to provide them within the new copy within 30 days of when those changes were made. And then the step 4 is that employers must keep a copy of every written policy on disconnecting from work for 3 years after the policy is no longer in effect. So next slide, please. So employers, step 1, employers are to determine if they are required to have a written policy. So this would apply to employers that employ 25 or more employees on January 1st, 2020. So who should be included in this count? So anyone who meets the definition of employee, including employees who are on a leave of absence, employees who are on a layoff, so long as the employment relationship has not been terminated or severed, home workers, probationary employees, some trainees, employees on definite term or specific task contracts of any length. So they could be on a task contract of 3 months or 1 year, but if they're employed at January 1st, they count. Employees who are on strike or who are locked out. Employees who are exempt from application of parts of the Employment Standards Act, and officers of a corporation who perform work or supply services for wages. So part-time employees and casual employees, they all count as one employee, regardless of the number of hours that they work. Assignment employees, so they are employees that have been assigned to a business by a temporary help agency, are employees of the agency and are included in the count to determine if the temporary help agency has met the 25 employee threshold. So assignment employees of temporary help agencies are not included in the count to determine whether the client the employee is assigned to meets the threshold. So in a nutshell, if you have temporary help agency employees working at your site, they are not included in your count. The agency's count must include all of the assignment employees, whether active or inactive on January 1st. So also, if an employer has multiple locations, all employees employed at each location in Ontario must be included. If there are 2 or more entities that are considered to be related employers under Section 4 of the Employment Standards Act, all those employees employed in Ontario by these 2 or more employers are included. And the number of employees on January 1st of any year determines whether or not the requirements apply. It doesn't matter whether the number of employees changes throughout the year, whether it goes up or down, it's the number that's in place on January 1st. So you can find more examples of who's included in this at the ontario.ca ESA guide. Next slide, please. So step 2, if answers under step 1 is yes, then the employers are to prepare their written policy. So they need to ensure the written policy is about disconnecting from work, as like that definition we discussed on one of the other slides. It includes the date the policy was prepared, any changes were made to the policy. So if just changes are made, it needs to have an updated date on it. It applies to all employees, so the content of the policy does not need to be the same for all groups of employees. And it is in place by June 2nd, 2022. So for all other years after this year, when you do your count on January 1st to see if it applies or if changes need to be made, you need to put that policy in place by March 1st of that year. So, and again, employers may wish to consult a lawyer when developing their policy. So examples of what could be included: the employer's expectations, if any, of employees to read or reply to work-related emails or answer work-related phone calls after their shift is over. Employers' expectations for different situations depending on the time of the day of communication, the subject matter of the communication, who is contacting the employee. So that could be a client, a supervisor, or a colleague. And requirements to turn on out-of-office notifications or changing voicemail messages when the employee is not scheduled to work, to communicate that they will not be responding until the next scheduled work. So those are some examples of what could be in the policy. So next slide, please. So it's important to note that the amendment does not require an employer to create a new right for employees to disconnect from work and be free from the obligation to engage in work-related communications in the policies. Employees' rights under the ESA to not perform work are established through other ESA rules. So this amendment has not changed any of the Employment Standards Act existing rules on limits of hours of work, required rest periods, and what is and is not considered to be work performed. The amendment does not require employers to develop policies that give employees more time off than what is in the Employment Standards Act existing hours of work rules, or any additional rights to refuse to work hours that were not in the Employment Standards Act existing hours of work rules. So some examples of ESA rules that provide employees rights to not perform work include the hours of work and eating periods part of the Act. For example, there are daily and weekly limits on the number of hours most employees can be required to work. So the daily limit is the maximum number of hours most employees can be required to work in a day, which is 8 hours, or the number of hours in any established regular workday if it is longer than 8 hours. So that could be your 12-hour shift or a 10-hour regular shift. The only way the daily maximum can be exceeded is by written agreement between the employee and the employer. And there's also weekly limits, which is the maximum number of hours most employees can be required to work in a week, which is 48 hours. The weekly maximum can be exceeded only again if there's a written agreement between the employee and the employer. So in addition to these rules, in that part, establishing that employees are entitled to a minimum number of hours free from having to work, daily, in most cases, an employee must receive at least 11 consecutive hours off work each day. This requirement cannot be altered by a written agreement between the employer and the employee. And between shifts, employees must receive at least 8 hours off work between shifts if the total time worked on both shifts is more than 13 hours. And there are weekly or biweekly amounts. Employees must receive at least 24 consecutive hours off work in each work week, or 48 consecutive hours off work in every period of 2 consecutive work weeks. So next slide, please. So step 3, employers must provide the written policy. So employers must provide a copy to all employees in the appropriate format within 30 days of either when the policy was created or to new employees within 30 days of being hired. So the employer does not need to provide a copy of the written policy to employees annually if the policy has not changed from the previous year. The employer may provide the policy to employees as a printed copy, an attachment to an email if the employee can print a copy, or a link to the document online if the employee has a reasonable opportunity to access the document and a printer and knows how to use the computer and printer. So, for example, it would not make sense to provide someone who operates a crane a link to the document online if they don't actually have access at work to that computer or printer. Next slide, please. So step 4 is that employers must keep copies of the written policies. So the record-keeping requirement is that employers retain a copy of every written policy required by the ESA for 3 years after the policy is no longer in effect. So for example, if an employer makes a policy on June 2, 2022, and then in January 2023 relooks at its numbers and changes its policy for whatever reason, the policy written on June 2, 2022 will need to be kept by the employer until January 2026. So next slide, please. So enforcement. So there are some consequences to not complying with the disconnecting from work policy requirements. Employees can file claims if the employer is not complying with the requirements, and the ministry may also be proactively inspecting whether employers are complying. Employers who are found to be contravening the requirements can be ordered to comply, or they can be given a notice of contravention, and that is can be an escalating monetary penalty. So it's also important to note if the employer's written policy on disconnecting from work creates a greater right or benefit than an employment standard under the Employment Standards Act, that greater right or benefit may be enforceable under the Employment Standards Act. So if the employer's policy on disconnecting from work does not create a greater right or benefit, the policy is not enforceable under the ESA. So for example, an employer has a policy in place stating that employees are not required to answer work-related telephone calls after their shift is completed. However, the employer does not honor that policy and requires an employee to continue to answer work-related calls after the shift is over. Unless the employer's policy amounts to a greater right or benefit under the ESA, no enforcement action can be taken by an employment standards officer relating to the new requirement for the employer to have a written policy in place. So the employer meets, if there's no greater right and benefit, meets that requirement by having the written policy in place. Next slide, please. So there's other employment standards rules to consider. Unless exemptions or special rules apply, employers continue to have the obligation to follow other rules under the Employment Standards Act that relate to time free from work, including hours of work and eating periods. So there are daily and weekly limits on hours of work. There are also rules around meal breaks and requirements to be free from work daily, weekly, bi-weekly, and in between shifts. So we just discussed some of those. More information can be found at ontario.ca/hours of work. There's also vacation time with pay. So there's rules around the amount of vacation time and vacation pay that an employee must be given. And for more information on that, you can visit ontario.ca/vacation. Public holidays. So Ontario has currently 9 public holidays each year. Most employees are entitled to take these days off work and be paid public holiday pay. For more information on that, you can go to ontario.ca/public holidays. Next slide, please. So this page just has some resources that are available to help you sort of navigate through the Employment Standards Act. And there's some great tools as well online that employers can access to help them provide, to help them do the calculations for some of the standards. So I understand these resources will be given to you. So hopefully this presentation has provided some clarity with respect to the new requirements under disconnecting from work. And thank you for your time. And I'm not sure if we have time for questions, Elisha?
Yeah, thank you so much, Valerie. You know, whenever I have to speak to legislation, it's not always an easy thing to make sure you're speaking to, you know, exactly the way it's laid out. But I believe the way you presented it to everybody made it really easy to try to think about our own circumstances and how to apply it. So just thank you for taking the time to do that today. There are a couple questions that I thought we could do now, and what we don't get to, we'll bump until the end. So I have a question in the Q&A that says, how will paid on-call incentives affect this policy?
That is a very good question. And I don't really have an answer for that one. That is one that's coming forward. So some of the program is still working on some of the interpretation around some of these pieces. Currently, though, under deemed work, if you are on call, so if you are normally, if you are at work holding yourself available to work, you are considered working. But if you are on call and you're holding yourself available for work at home, then you are not considered to be working. So that is a consideration that employers are going to have to take into consideration when they're making their policy. And I'm not sure if Robert and Alana may have more insight onto that, but otherwise we can certainly go back to the program and find out if there's more clarity with respect to that question.
Okay. All right, Valerie, sorry for throwing a challenging one at you firstly. There is another question here that speaks to the officers of the company. So, you know, would this right to disconnect legislation apply to the officers of the company? So directors, managers, superintendents, and supervisors?
Well, yes, it would. So the policy requirement is required for all employees of the employer. It includes management, executives, shareholders or officers if they are actually employees of the corporation. Okay. So they would also be included in that that legislation. So but it also doesn't mean that the employer has to have the same policy for all those different groups, because an officer who does some work at the corporation may look very different than a frontline worker or a shift worker in the factory. So when the employer writes their policies, they can write different policies for the different groups, or they can have one policy that will address different groups within that policy.
Okay, that kind of, yeah, no, that's good. It was going to line up with the question I had for you, which was, when you have employees in different positions, does the policy have to cover all of them? So
yeah, so it does cover all of them, but it can look different in how it covers them. And that only makes sense, right? Because in one organization, you can have some very different types of workers. You can have 24/7 and you can have 9 to 5s. And so it only makes sense that you would sort of tailor your policy to your environment.
Okay, good. Very helpful. And what I have a personal question that I wanted to ask you, Valerie, and I didn't give you a heads up on this question. So
okay.
hopefully it's not going to throw you off too much, but for yourself, and because, you're working hybrid, your home, your office, do you have a tip that you use personally just to create the boundary between work, right? When your work is done, is there a practice you do to kind of create that disconnect on your own?
Actually, I do. I know I worked from home quite a bit prior to COVID. So I had sort of put that in place. I turned my computer on when my husband left for work in the morning. And when he walked in the door at night, I turned it off. So, I mean, I probably gave the employer a few hours, but that's okay. But I also work in my office, and I don't usually take my work out of my office. So my office is my workspace. So when I leave there at night, I shut that door, it's done. However, if I heard my work phone ring, which I also leave in my office, I may run and see who it is, just in case it's a claimant who I've been struggling to contact. But generally speaking, I shut that door, because otherwise your work and your life just become completely one. So there are, yeah, that's all I can say on that, really.
I think each of us, who have been, sort of under a pandemic, or even before that, where you've been sent home to do work, remote work, I think we've all created our own little strategies in an effort to do it, right? It's not always easy to keep the lines or the boundary lines 100% clear between work and life, but I like the idea of just keeping all of your stuff in your office, in the dedicated space in your home, and trying to leave it there. So I think that's a good strategy.
Yeah, that works for me, but that doesn't mean it's going to work for everyone, right? Everybody has to kind of figure out how that happens. So
yeah, very good. Okay, there is maybe time for one more question here, and one has come up in the question and answer area. So it says, if the person is on standby to answer calls, should someone call in, would they be considered working?
Well, I mean, that would depend on I'm not quite understanding the on-call piece there. Normally you have a policy if someone is on call. Now, if you are on call at the workplace, it is considered to be work time. But if you are at home on call, that is different. That is not deemed to be actual work. Most policies say once you get that call, you are now working. So it would very much depend on what that policy is, but it also speaks to the fact that this has implications on all different kinds of policies and procedures and the way people are handling their work. So I think that's a really good point, to ensure that when you're writing your policies that you're considering that as well.
Okay.
But in terms of the actual legislation speaking to that, yeah, I don't have that information. So we'll see if further updates, there will be further updates coming from the program with respect to interpretation around this policy. And that's where it's good to always go back and look at the guide and see what the latest and greatest pieces are in the legislation.
Okay, great. Thank you so much, Valerie. And before I sort of move into our next speakers, is there anything else you wanted to add before we make that transition?
No, I thank you very much for this opportunity. I mean, it is a new thing, and it's really helpful to share with employers, because when employers do it right, that makes my job so much easier. And yeah, it's something that that should be of an interest to, well, any employer with over 25 people right now. And I thank you for the opportunity, but I'm also looking forward to hearing to what Robert and Elena have to say. So I look forward to that. Thank you.
Okay, perfect. Thank you, Valerie. Okay, well, I mean, you've heard it, Robert and Alana. Valerie is looking forward to hearing what you have to say, and I think it's a good opportunity to transition from one presentation into the next. We have a better understanding of what the legislation is and isn't, and where to find that information. I'm wondering now if Robert and Alana are able to take themselves off of mute and show their faces to us.
Hi there.
Hello, hello. Thanks for joining us today.
Thank you so much for having us. We're glad that we're able to have this discussion. And I think, Elisha, your conversation with Valerie and kind of how you ended it is actually perfect for where we're going to be jumping in here and kind of talking about that, you know, hybrid workplace and how that kind of pushed the need for the right to disconnect even further. So like you mentioned, my name's Alana and this is Robert, and we're lawyers at Suzanne de Rosier Professional Corporation. And today we're going to be talking about that hybrid work arrangement and the flexibility in the workplace, and how the pandemic has kind of been the driving force to that, and how that has led to the right to disconnect. So we know that there's been an added need for adaptability and flexibility and resilience from both employers and employees because of the pandemic. So that has kind of created a lot of change for a lot of employers, and having to learn how to you know, change their workplaces from operating one way into operating in different ways. And for some employers, this has been great, and it's made a lot of advancements. For others, it's been more difficult. So I think it also depends on the context of the organization. So we're going to be talking about that today. Okay, so we're going to share our slides here. All right. Okay. Oh. There we go. Okay, so like I said, Robert and Alana, and you can reach us here at this contact information. This is a copyrighted presentation, so please don't distribute it. And then this is going to be just a general conversation. We're not giving legal advice specifically for specific situations, but if you do have some scenarios that you need some advice about, feel free to retain our services and we can help in that regard as well. All right, so the hybrid workplace and the right to disconnect. So Robert, like with this whole, I guess, hybrid workplace that has started here, what do employers need to know about this?
Thank you, Alana, and thank you, Elisha, for the introduction. I'm excited to join everybody this afternoon. I can see that we've got quite a broad range of participants from across the province and even in other provinces as well. I'm happy to present to you. Excited to speak about employment law, which is quite interested to me, and particularly this topic, this right to disconnect. It really seems to be hot property right now. So with respect to the hybrid workplace, what do employers need to be thinking about? These developments have kind of been thrusted on employers, not so much by choice. When we were facing a wave of lockdowns in the early 2020, many workplaces were forced to be shut down, and remote work sort of evolved as a bit of a necessity. And now that we're seeing some of the restrictions being lifted, there's a new tension kind of developing between many employers who would like to recall some of their employees back into the physical office workplace setting, and between some employees who have really adapted their lives around this work from home model, and they are enjoying some of the benefits that that comes with it, which is Alana is going to speak to. So this has been a tension that's being discussed quite often. And we've got this this notion of the Great Resignation, which you might have heard of. So an element here that's important to keep in mind is choice. Okay, so generally speaking, the employer is in the right to direct its workforce that they should return to the physical office setting. But right now, it's more of an employees market than it is an employer's market. There's a lot more people hiring right now. There's a shortage of skilled positions, and employers are increasingly need to adapt their way of doing things to kind of meet with employee expectations. And if they take too rigid of an approach, they might find that their employees are looking for opportunities elsewhere, because the opportunities are abundant right now. And other employers are willing to be more flexible with this kind of remote work. So although when we talk about this remote work, we want to keep in mind that we want to touch on these trends of the hybrid workplace and what's been developing, but we're also mindful of our audience, that many of them and many of the viewers of organizations that are being represented, remote work is simply not an option, right? I mean, you can't operate a manufacturing facility remotely. You can't drive a forklift from home. So parts of our presentation are going to be geared towards that as well. So Alana, I'd like to ask you, what are some of the benefits that we've observed with hybrid workplaces?
Yeah, so there are a lot of benefits. And as Robert said, there's also, some I guess employers and employees where this kind of hybrid model doesn't exactly work. But for the ones that it does work, we're seeing a lot of increased employee satisfaction, increased employee productivity, so lower overhead costs, less distraction, and able to focus a little bit deeper. And when people are in the office, usually there's more room for wanting to connect more when they do come in and out. If they're doing kind of, some remote work and some from the office, we're seeing that. It's also easier for accommodation purposes too. Tends to be better for employee retention. It's attractive for hiring. There's all of these different avenues, and we've seen improved mental health for some individuals as well, and just that better health management, being able to be from home if that's something that they enjoy. But there are also a lot of drawbacks as well. So Robert, I'll have you speak to some of those drawbacks, and one of those is that that need to disconnect from the workplace, and that work-life divide isn't always there. So is there anything that you have to say towards those kind of considerations and drawbacks?
Thank you, Alana. As I was sort of hinting at, one of the major obvious things is that not every position can even be performed remotely. Like a hybrid workplace is not always an option in the first place. And where it is, there are some drawbacks as well. Many employees have kind of expressed a perception that they've lost a sense of connection with their colleagues when they're just doing Zoom kind of video calls and there's no in-person type of collaboration. And this is a trend that we see not only in workplaces, but it has been observed in the education setting as well. For example, with students that are now attending university and classes online through Zoom, there's been kind of a wide kind of perception that some of the collegiality and the benefits of that in-person interaction have been somewhat lacking. And I'm sure, as we're going to find after we're finished giving this presentation, the Zoom calls can be exhausting, and having the camera always on, right? And, some of the remote work can kind of might place a strain on some people's personal kind of family relationships, right? We have to think about what the employee's work environment is. Not everybody has a nice, 3-story home with 1,500 square feet. Some people are cramped into a small space. You might have many members of your family living there. You might have a dog or cat and pets as well. And, your office station might not be so secluded. Let's say you just have a 1-bedroom condo, for example. It was mentioned earlier, I moved up from the GTA, and that's sort of the norm around there. It's hard to create that kind of dedicated space where you can really focus in on your work, right? And especially for people who are dealing with childcare obligations as well, right? If you have a small child or a baby that's, taking your time away, it's hard to kind of focus in and put the hours in on work. Whereas, generally you would otherwise have kind of a clear divide between just this work life and home life, right? Just speaking for myself, one of the earlier questions that had finished off with Valerie was what do you do to kind of mark yourself at the end of the day? Well, I mean, I just have one computer in my home, right? And so during the day, you're working on it, doing your work tasks. And then at some point, like on my off time, I like to play kind of, video games, computer games. So it's the same computer I'm doing work on, but then it becomes a leisure activity as well. So that, I mean, the boundaries are kind of blurred there a little bit. So turning it back to you, Alana. So, there's kind of a recognition that a hybrid model is not possible or it won't work in every workplace. What do you kind of suggest like employers might do to kind of work around this?
Yeah, so there's a few different options to remedy this kind of, divide. But there are a lot of essential workers who have had to be on location. They haven't had that added luxury of being able to work from home. So sometimes what that happens is we're seeing this kind of divide between an us versus them culture in the workplace. And this can create a lot of frustration between employees as well. So I think one way that an employer can kind of mitigate this risk a little bit is by providing a little bit more flexibility for those individuals who actually do have to remain on location, and making sure that they do have ways to disconnect as well. So more flexibility in different ways could look like, maybe helping them to schedule shifts that are more preferable to them, that allow them to manage their work and their life a little bit easier. And then we also have other ideas, maybe doing a compressed work week for some individuals, if that's something that's going to work better for them, or maybe allowing more paid time off or other incentives that an employer can offer to kind of help those employees to feel as though they're not getting, getting a little bit less than other employees who have the privilege of working from home. And so one thing that we've noted is a lot of our audience obviously has to do with the mining, pulp and paper, forestry, all of those kind of sectors. And many of those positions would not be able to have been done from home during the pandemic. So I think a lot of you might have actually had to go into work during that. And we thank you for that. But we know that there are a lot of struggles and extra demands that come with that during the pandemic as well. And so this right to disconnect kind of thought might not apply in the same way as it does for those who are working from a hybrid kind of perspective. So Robert, do you have any idea of how maybe this might affect those particular industries, or, just any comments on that about maybe more selection in shifts or different incentives or those kind of things?
Thank you, Alana. Yes, I have given this some thought, and although the requirements under the Act are clear that this policy needs to apply to all employees, first of all, it doesn't mean that all employees have to be governed by the same policy, okay? So when you're making distinctions on your policy, you want to make sure they're rationally connected and based on the employee's job position and defensible. You don't want to ever have an arbitrary or discriminatory distinction in your policy. But for many employees, and I would like to disclose, I have experience working in a manufacturing facility, an automotive parts manufacturing facility, and automotive fluids. I have worked on a type of assembly line. And, when we talk about disconnecting from work, right? For many employees that are not managers, or if they don't have supervisory authority or control over operations, they're really only performing work and engaged in work when they're there on shift, when the plant is running, and during their scheduled work hours. They're not, at the end of the day, they are already effectively disconnected within the meaning of this legislation. It's not to suggest at all that the policy doesn't need to be in place. It clearly does, and it has to apply to all employees. But what I want some people to kind of think about is that many of the employees within an organization are not necessarily being inundated with these work-related communications off their regular hours. They're already kind of disconnected, if you will, when the clock is over and they punch out and they leave. The other thing to keep in mind is that when it comes to supervisors and managers, you might want to have different kind of policy provisions, different expectations there, because they are the ones that are expected to, plan for and make sure that operations are running smoothly. And for example, a plant or a facility, and that may well require communications outside of regular work hours. And in fact, it's often expected. And one of the interesting features of this legislation, which I think that we're going to see develop as time goes on, under the Employment Standards Act, there's exemptions around hours of work requirements for managerial and other type of professional employees, recognizing the kind of thing that I'm talking about. Right now, the way this policy doesn't have exemption in place for those other employees, but as I've said, it's open to the employer to craft a different policy for different classes of employees to kind of accommodate that. Mm-hmm. So, Alana, I'd like to ask you, do employers have to continue allowing remote work or a hybrid work arrangement once the pandemic restrictions are over and it's been lifted and we're all safe to go back to normal?
Yeah, I mean, so technically, no, employers are not obligated to continue operating this way. So they can ask their employees to come back to a physical workplace if that's the regular way of operation. They can say, come back to the office. We'd like you back here now that the pandemic has lifted and some of the regulations have been lifted. But one caveat to that, of course, is to look at the employment contract of the employee. So if they were hired during the pandemic, they may have had an employment contract that actually stipulated that they are to be a remote worker and that they are, permanently going to be in that position. So if the employer were going to say, oh, well, the pandemic is kind of lifted now and let's all come back to work, and they force that employee to come back to work, then they're opening themselves up to something called a constructive dismissal. So that's something that employers would want to be really careful about with that. And of course, that's a little bit of an aside from our topic here on the right to disconnect, but just with thinking some of the questions that have come up in the first section having to do with calling in. So the way that I've seen this is it kind of differs if it's a union setting or a non-unionized environment. And so if it's a union environment, then typically in a collective agreement, you're going to see those like on-call employees. They're technically not working, but because they're on call, they might be getting some kind of extra wage for that. Or if they pick up the phone or they go into work or they answer the email or attend to the emergency or whatever it might be, then technically they are working. So most of the time what we see in collective agreements, at least what I've seen in my experience, is that they are considered to be working. So when it comes to the right to disconnect, employers need to be mindful of that and make sure that that's in their policy to say that if an employee is on call and they are supposed to be disconnecting at the same time, it's a bit of a contradiction. So when an employer calls an employee in, if they are on call, then they are considered to be working. And usually they're paid for the minimum 4 hours, even if they only answer one phone call, right? So, I mean, we could go into that and explore that in more depth, but I think as an employer, that's something that you need to be really mindful of and very careful with, particularly when it pertains to a certain policy for certain employees. Of course, it's not going to apply for every single employee. You don't have to say that if you answer one email when you're off work, if you're not on call, then you're going to be paid for 4 hours or anything like that. You don't have to change all of those kind of policies, but you do need to address them if your organization already has them in place. So moving forward, of course, when we talk about kind of more of these additional considerations here, we're thinking a lot about providing healthy and safe workplaces as well within the realm of that flexible work arrangement of working from home. And so, Robert, does this still apply? Like, do employers still have obligations to provide that, like, Ontario health and safety kind of obligation to the employee when they are working from home?
Absolutely. There's no question that they do. So if an employee is working from home, then that employee's home becomes an extension of the workplace, and the requirements under the Occupational Health and Safety Act with respect to ensuring the safety of employees at work apply to the employer in respect of that remote work location. So it becomes an extension of the workplace. If an injury occurs on the job, and this has led to some kind of interesting kind of questions and commentary, what happens if somebody trips down the stairs when they're coming down in the morning? Is that a workplace accident? We report that to the Workplace Safety and Insurance Board. But, but broadly speaking, an employee's physical home can still have risk and contain hazards, ergonomic, electrical, fire, environmental hazards, and essentially the employee's regular standard obligations under the Occupational Health and Safety Act do not just go away. And as a best practice, the employer should be asking employees to do an inspection of their workstation. There's kind of forms and precedents available for that. You have to be mindful of an employee's privacy interests as well in this regard. But the short answer to the question is yes, you don't get a free pass from your occupational health and safety obligations when an employee is working at home. And Elena, do employers still need to accommodate employees who are working from home?
Yes, 100%. So that duty to accommodate still applies. Of course, it's still to the point of undue hardship, but I mean, it doesn't mean that an employer would have to, install a fancy lift system inside an employee's home who has an injury or something like that. Like, of course, not to that undue hardship point, but it is still important to be asking your employees how you can accommodate them if they do have accommodation issues. So now that we've kind of discussed where the background is and kind of how this is set up, this new landscape for the right to disconnect, we'd like to kind of transition into that topic now and discuss how that right to disconnect is going to affect the hybrid workplace and how it's going to affect those who are still on location. So now that employees are working from home, they might be tempted to work some longer hours, like they don't turn the computer off right away because they feel like, well, I need to get a little bit more done, or, I've got nothing else to do, we're in a pandemic, or some of those comments we've seen. So now that those, attending to work tasks is becoming a little bit more common, that life divide between work and life is not happening. So how does that right to disconnect now affect these hybrid workplaces?
Thank you, Lana. Yes, I think in response to this question, there's been what you've described as this sort of always on culture, right? And as I was kind of alluding to earlier, it's a little bit, your work desk, that's where you're doing work during the day, but then after whatever, 6 or 7 o'clock, you go there and have your leisure time. And you know what I mean? These are challenges that people are facing. There's not always a clear kind of boundary between when does work start or stop. But it's important to mention in this context, employers need to make sure that they're abiding by their record keeping obligations, unless they have an exemption for that. But it's important to keep track of the time that employees are working. Some employers are finding themselves being essentially hit with overtime liability that they weren't expecting because an employee is performing work outside of regular hours. It's required or permitted the work to be performed. And it's not as easy as when they're physically there in your workplace and you're in the office and you can shut it down at 6 and turn the key. And you know what I mean? So be mindful that you have to continue your monitoring hours of work and making sure employees are appropriately compensated for that. So with respect to the new policy, the right to disconnect, the hot property, Alana, what does the act require of employers to do?
Yeah, so I think Valerie did an amazing job on, outlining exactly what the act requires. But just to reiterate that a little bit is that employees or employers who have more than 25 employees must create that written policy that outlines disconnecting from work. Again, disconnecting is defined as not engaging in work-related communications, including emails, phone calls, or the sending or reviewing of messages, so as to be free from the performance of work. So this definition, of course, doesn't encompass absolutely everything. Everyone's job is a little bit different. So some people's jobs will not include emails and phone calls and those kind of things. So just be mindful that disconnecting is not an all-encompassing kind of exhaustive definition, and that there is some flexibility in what that means. And I think this is where it comes down to the importance of the employer actually drafting these policies in the way that is unique for their organization, because I mean, just generally, policies need to fit like a glove. It's very important when workplaces have policies that they're not just going to sit on a shelf and collect dust. They have to be ones that can be properly applied by supervisors and enforced if they need to be. They need to be ones that are going to fit the organization itself. So employers need to be really mindful of that when they're drafting these policies. And then as we're talking more about these policies, I know we've discussed it briefly, but Robert, can you just kind of reiterate for us a little bit about what needs to be in these policies? Sure.
So we're coming now to the part of the presentation I think everybody's the most interested in. And I'll give you a disclaimer up front. I'm not going to purport to kind of say what the legislature might do in the future. As Valerie's kind of set out and has done a great job of setting out, employers have a lot of discretion as to what they're going to contain in this policy. It's important to reiterate again that this new amendment does not create a substantive right to disconnect from work. It needs to be a policy that's about disconnecting from work. So let's talk about some practical considerations, okay? So when we talk about a workplace policy generally, we always want to be giving advance notice of the policy, okay? So if it's due on June 2nd of this year, you don't want to be rolling your policy out on June 1st or something like that. You want to be rolling it out well in advance. Now, I think it's important, as I was alluding to before, give some serious thought about how this would affect your operations in practice. You might not want to have a blanket policy that applies, especially for a large organization. And keep in mind, this is only applicable to 25 or more employees, right? So when you've got multiple levels of reporting structures and employees, I would suspect that it's not appropriate to have the same requirements across the board for all of those employees. So you'll want to give some thought about how the right to disconnect would apply differently, and especially for supervisors and managers, okay? And you need to be careful about creating a greater right or benefit under the Act, because the requirement that's in place right now is very minimal, okay? It could be an aspirational kind of statement that essentially the employer would try to value to the much greatest extent possible, disconnecting from work, and would like to work with their employees in that regard. And something of that nature would essentially satisfy the requirement of under the Act, of course, subject to the other kind of notice and requirements that Valerie set out. But what I want to get across is be very careful about putting something in a policy. No employee is required to pick up the phone or answer an email after 6 p.m. or something like that, because it could be very difficult for you in practice. And once that you've created this right and you've given it to your employees, it can be hard to take it away. Of course, we want to, be mindful of everybody needs a work-life balance and that type of thing, but you don't want to find yourself in a position where you've got an urgent situation going on in the workplace, and maybe it's over the weekend or it's off hours, and you're trying to contact your employees, you need some help, and nobody's picking up their cell phone, and they come in to you the next morning and tell you that they were disconnecting. Okay, so be careful about not kind of overstepping and putting in the policy things that aren't going to work from your organization from an operations perspective. Be careful about creating a greater right or benefit under the Act. That's essentially what I would say about what should be in the policy. The Ontario government has set out some kind of guidelines, things to consider, which were already covered in the other presentation. So I won't go over those again.
Those are some really good points. Yeah. And I think that's those like little practical considerations that are most important as employers are drafting these policies. And we are hoping that we'll be given a little bit more guidance in the future, that we can have a little bit more of a substantive maybe guidance on the legislation, just so that employers actually know what is really required of them. But one thing that's really important to note here too is that if an employer has a policy on this topic, then they've met their obligation. So that's basically how simple it is. But with that comes a lot of power and choice in what's actually going to be in it. So I think an employer can actually really use this to benefit their employees, to benefit their organization, to increase employee satisfaction and all these things. So we're seeing that it is a good step in the right direction. In practice, we're not sure how effective it'll be yet, but we think that with more guidance and with more experience as employers start to roll out these policies, we do think that it'll be a good way to start discussing more of that workplace and home life divide as well. One other thing too is that despite the title right to disconnect, we want to be very clear that it doesn't actually create that substantial right. And like Valerie and Robert have both said, those substantial rights come under the Employment Standards Act for the employees. So just because there is a policy that says a right to disconnect in it doesn't create an actual hard and fast rule that this employee has the absolute right, no matter what, to disconnect when the policy outlines. So kind of how this would affect that hybrid workplace, Robert, maybe we'd be starting to see employees who are working, 12 till 8 p.m. They're not permitted to correspond with other employees, or how would they kind of deal with that in practice if a policy was put in place? How would that kind of work in practice?
Yeah, thank you, Elena. And I think something that could be helpful in this discussion as well, right, is that it's not engaging in work-related activities when the employee is not scheduled or required to work, right? So I think there's a tendency to think of this in terms of like 9 to 5, 5 o'clock off time. It's not so much based on hours of the day. It's based on when the employee's regular work day is set up under the Employment Standards Act. And this is going to look different, for example, for what they call a continuous operation. It's running 24/7. You have a day shift and you have a night shift, right? Sorry, Lana, could you maybe jog? So with the working 12.
Yeah, so I guess like the concept that we've been kind of thinking about a little bit is like for some organizations, if an employee, for example, works 12 to 8 p.m., that's a different shift. It's not your normal regular 9 to 5 kind of shift, right? So if somebody emails them, outside of their shift, are they still required to answer that because it's an important email, or, kind of like those kind of questions are emerging with this. And I think that's where we're seeing a lot of gray area with the legislation, is that we're not exactly sure how to respond to these. And I mean, even Robert and myself, like we're lawyers who, deal with this kind of thing all the time. And it's still questions that sometimes will stump us because we don't actually know exactly how it's going to play out in practice. So I think that just comes back down to waiting to see how it plays out, how each organization is different and how each circumstance is different, and making sure that employers are following the Employment Standards Act above all else, of course, not contracting out of that, and just learning how to deal with these kind of difficult scenarios and questions that we don't always have answers for.
Excellent. Thank you for jogging my memory, Alana. So yes, and with regards to this, the original question, right, and being based around the employee's regular scheduled hours of work. So not all employees at the same company may be regularly scheduled during the same time. So you could have somebody, for example, that's on a 9 to 5 schedule, somebody that's on 12 to 8. The person who sends an email at 7 o'clock on a 12 to 8 is within his or her regular working hours, but it's outside of the other employee's regular working hours. So that's kind of the importance of the distinction to keep in mind. It's not so much based on the hours of work, or the hours of the day. It's based on the employee's regular work day, whether they're be engaging in communications outside of work. Now, I think an interesting piece to add to this is that it's not always only coming from the employer when there's communications outside of an employee's regular workday. Often it can come from coworkers, especially in a larger organization. It's not always the boss that's kind of ringing you outside of work or sending you emails, hey, did you follow up on this, or what's the status of that? Often you could be in a workplace setting. Ours is familiar to, I'll speak what's familiar to us as a law firm, but I mean, you could easily have another associate emailing you outside of regular work hours, talking about a file, talking about a case, asking you about this and that. And are you required to respond to that communication? But also the interesting piece, right? How does the policy fit around when it's not only the communication is coming from the employer, it could be other coworkers that are putting demands on employees outside of their regular working hours as well. So that's the kind of piece that,
or even clients, right?
That's like, right. Yeah.
Outside third parties coming in there too, which
certainly
creates even more confusion. So.
Right. And so, so all of those things you want to give some thought into your policy. But as I was kind of going back to that, it doesn't, the policy requirement, you're not required to create a substantive right to disconnect. I would be careful to confer one without very carefully kind of thinking it out. And for all the employees out there, I would essentially say, and be very careful about, don't ignore your boss or your supervisor outside of your work. You might be doing so at your own peril.
That's a very good point. Yes. And like that comes another thought that kind of pops into is that sometimes the workplace culture of different organizations, employees actually want to put in a lot of time. They want to put in and show that loyalty and that devotion to their workplace, right? So we have some employees who feel that that is a way, by spending extra time, by putting in their extra effort, is a way that they can, maybe climb that corporate ladder if they want to do that, or, just benefit the employer who has benefited them in many ways. So we also have to be mindful of that and how that is going to kind of change the workplace culture if there's a right to disconnect policy, because then it kind of takes away or limits the ability of those employees to kind of, show themselves as loyal employees. So I think it's good though, because I think it creates a little bit more room for employees to maybe use other ways to show their loyalty and other ways to want to progress in their career too, that maybe aren't going to affect their mental health quite as much, or, leave more time for family or for the things that they want to be doing in their lives too. So I think we are seeing that it is a good shift in the right direction. And I think it comes down to, of course, is that it has to be unique for each organization, and how that's going to look is different. And I think that's probably why the legislation is so vague, is because there's so many different considerations. I mean, we've talked about a few, but there's so many more that we haven't addressed that would need to be considered in these kind of policies.
Thank you so much, Alana, and I want to thank everybody for your attention. Those are kind of the points that I would like to get across in this presentation. I want to leave some space for questions. Is there anything else that you wanted to add?
Yeah, I think that's pretty much it. I mean, there's always more, but for today, I think we've covered everything that we need to, and we'd love to get some questions from the audience.
Okay, so we'll get ready for the hot seat now, and we'll see what kind of curveballs you can throw our way.
Yeah.
Okay, so thank you very much to both of you. I like the approach of just having the conversation through those different pieces for all of us to reflect on. You did cover the question in the Q&A around entitled to overtime by answering a call to deal with a situation outside of regular hours, or entitled to declining answering the call. I think you captured that in one of the answers you did at the end, so I don't know if we need to go there. And there really aren't a lot of other questions popping up. So my hot seat question to you is, because both of you do have this hybrid workplace, you're in the office, you're at home, you're at the courthouse. How do you go about disconnecting from work to create a boundary?
That's a really good question. I guess I'll start off with that. I think for myself, sometimes I have the tendency of wanting to please people. So I have to set some pretty strict guidelines, because I do have a family at home that needs me. I do have other obligations and volunteer things and friends and all this kind of stuff. So I think for myself, one of the ways that I when I started this work, I set a boundary for myself and an intention and an expectation, and said, okay, unless something is actually really needed, I'm going to leave when the workday is done. And then if I have to attend to something at home, I usually bring my laptop home and I'll deal with it if it comes up. But if there's nothing that's pressing, if there's nothing that my employer needs today, if there's no clients upset needing to put out fires or anything like that, then I try to go home at the end of the day, because then I have people waiting for me there that need me just as much as the employer needs me here, right? So, and I think when I do that, it helps me to be more productive when I am here, when I am working. I focus on work, and then when I'm at home, I focus on home. So that's one way that I've done it. Also, when I am working from home, I tend to try to stick to the one office environment, just like Valerie said. I keep everything in the one room, and then when I'm done, I leave that room and I kind of leave it behind. But yeah, what about you, Robert? What are some ways that you like to disconnect?
Thank you.
Robert works some long hours sometimes. He's a very hard worker. So. Okay.
Thank you, Lana. I did kind of, and it's a good question, I did kind of allude to this. I struggle with this to an extent, and I was kind of saying, if you're using the same computer or device to do work as you're doing to play games or whatever, that for me is like a mental thing where it doesn't feel like there's ever a complete kind of separation there. I think it's also a really deeply personal kind of question as well. I think a lot of people have a lot of different experiences with this. For myself, I really do value having a physical workplace setting and it being separate from my home. I like when I leave the office at the end of the day and I clock out or drive home, I feel like that I'm done. But if I personally, and this is just a personal experience, other people have different experiences, I don't value the remote hybrid so much, because I do find that it tends to blur the work and personal, and I really like trying to keep them separate. The other thing too is when you're talking about your mental health, and part of what this is kind of geared towards and creating this kind of boundary. Well, if during your off time, like let's say you clock out, you're going to be stressed and worried about all these different tasks that you have, or different things that are coming, you know what I mean? For me anyway, and I assume some others out there, putting in some extra hours, it doesn't so much feel like, that you're overextending yourself, because if you're otherwise just going to sit there and kind of worry about this mountain of sometimes just tackling it is actually, I find anyway, the most kind of beneficial for me. But always it's a balance, right? You can't go too far, and you have to set boundaries. But it's a deeply kind of personal. I think it's different for each person.
And actually, just one quick little practical thing that I heard. I haven't exactly tried yet, but I've heard that it really helps. If you do something in your work life that is very hands-on or creative, that kind of work, then when you get home to transition, you should try doing something with your mind, like reading or writing or something along that side. And then if you do something with your mind all day, if you're working like we do with our computers all day, then you should try and do something creative when you get home to try and create that like bit of a break. So try it, let us know if it works.
I like that tip, Alana. That's really good. And thanks for answering that question. There are a couple questions that have popped up in the Q&A. And one of them here is just really reflecting to, and I'll just read it out loud. So it says, in short, is this legislation just a way to apply work standards to a remote work environment? As in, there were work hour limitations, which now have to be extended to remote work or work from home.
I think that's a really good question. I think we need to look at the intention of the legislation. I mean, if you look at the title, even as Robert has mentioned, Working for Workers Act, I mean, it shows that you're trying to, create a little bit more of that employee right and focus on employees and betterment in that. And I think a lot of negative things have come to the surface during this pandemic. We're seeing that, mental health issues have been at an all-time high, and we're seeing a lot of depression. We're seeing a lot of dissatisfaction in people's work and wanting to change that. So I mean, I can't speak to the creators of this act. I can't speak to what they actually really meant, but I think it might very well be a way that we can address some of those issues. Whether or not it works in practice, we'll see. But I think the intention is good. I think it is there as a way to try to, acknowledge that there is a problem and that they're trying to do something about it. And I think that's a good first step.
Right.
Yeah,
I apologize. If I could just take a crack at that as well. I think the question, I see where you're coming from. In my eyes, I think it is this remote work and hybrid environment that's really prompted this legislation. But and some of the challenges that have come with it. But as Valerie and our other presenter had set out, it's not really modifying the substantive ESA rules that are already in place around hours of work. And it's important to point out that the policy applies to in-person work settings as well, that everybody needs to have this policy regarding the right to kind of disconnect from work. So the short answer is, I think that the legislation was brought about by some of the challenges that we've seen emerge as a result of the new hybrid work kind of through the pandemic and the blurring of the work life. But it's not necessarily modifying the substantive kind of rules of the Employment Standards Act, and it applies equally to in-person and remote work settings.
Okay, great. I did want to see, Valerie, I'm not sure if you wanted to come on at all and answer some of these questions, but if you'd like to, you're more than welcome. I didn't extend an invitation back, but it would be great to get your perspective as well. There's a question here around what are the fines for not having a policy in place or not following the policy? Welcome back, Valerie.
Hi. Okay, so that's a question about enforcement, and we have a lot of discretion in our enforcement. So, for instance, if someone, I know I already have had claims where people have marked off disconnecting from work because employees don't understand what it is yet. But with respect to the enforcement, the first step is always going to be educating the employer and asking them to comply. And if they comply, that is kind of our end goal. Having said that, as with all things, there are some employers who are trying to comply and don't always know everything, and so they need some educational help. And there are also employers who purposely don't comply, and then we would use our judgment with respect to how we enforce that, what level of enforcement would happen. So I can't imagine that we're all chomping at the bit to run out and write NOCs for $250 for every employee that doesn't have the policy, but certainly the educational piece and helping employers comply will be our first step.
Okay, great. So, I see the question in the chat panel, and it's about, I think employees have the right to choose to disconnect as well. And while we spent a lot of time kind of talking on the policy side and building the understanding of what's going to need to go in there, there is this sort of background piece of how do we disconnect, right? So we could choose to just keep going. I don't know if at the end of the day there's extra pats on the back for that, but how do we kind of integrate this and educate workers on disconnecting and how to go about doing that? I don't know if there's any perspective on that question in the chat, but I'd love to hear it if you have something.
I can take that one. I think you answered almost your own question in that a little bit. You said education. And I think that's the key thing with this is that I think when it comes to employers or employees, of course, naturally, there should be a little bit of choice as to whether or not they want to put in the hours. I mean, if they do, I guess they're free to, but you also have to consider that the employer has obligations that they need to ensure that those employees are working within the parameters of the Employment Standards Act and adhering to those hours and overtime hours and things like that. So if an employee is going to go full force ahead and just, do a ton of overtime and they're breaching those obligations that the employer has, and the employer obviously has to deal with that and they have to do something with that. But I think on more of just a normal level, not thinking about the extremes there, I think education is a good place to start. Thinking about the reason that why we want to disconnect, thinking about the benefits of doing that and how disconnecting can help us to do a better job when we actually are working. So if we're always on, as the culture calls it now, I think we're going to have a hard time doing high quality work. So I think that's one consideration too, is that employees need to think about why they're disconnecting and then make that choice and ensure that they are not putting their employer in a position that is dangerous by working too many hours in that as well.
If I could also jump in there, so I'd like to add to that in terms of employees should have a choice if they want to disconnect. I think a part of this as well is the notion of people kind of voting with their feet. And it's a big part of what we've described as the Great Resignation crisis. So although I've outlined for you today that the requirement doesn't create a substantive right, you don't have to have a policy saying that you don't have to accept communications after your regular workday, you may well find yourself losing kind of talent and and it's difficult to attract people in on both sides of the coin, right? Either that you have somebody that wants to set a firm boundary for themselves and kind of shut their day at the end of the day, or for somebody who on the other side of the coin wants to engage like kind of well over their regular working hours. In both cases, the employer, this idea of choice and being flexible with the wants and desires of your workforce, because although you might not have a legal obligation to create this substantive right, if you're not responsive to kind of the temperature of the room, what people are looking for, they can kind of vote with their feet and look for opportunities elsewhere that do kind of give them more of that kind of balance that they're looking for.
Okay, great. I'm not seeing anything else sort of pop up into the chat, but thinking about it even just through my own lens and what that looks like, and linking it even with the question around linking legislation to the remote work. There's so much that as the work world has changed, understanding what the expectations are of workers or the expectation from the employer, right? This idea of just putting it all out on the table so that we better understand as a worker what's being expected of us, what is my employer doing to kind of support that, things like availability, communication, all of those have definitely flooded anybody who's been doing hybrid work or remote work, and opportunities to clarify that through communication, use of technology is really beneficial. And I think of an example that happened recently where I was reviewing a draft of our right to disconnect policy, and I like to get up early to work. So it was 5 in the morning. Here I am. I did kind of my review, had my feedback, and I'm about to click send on the email. And I'm thinking, oh, that policy had something about using the delay delivery. Okay, so there I am Googling how to delay delivery. I think we all just have to get better at using technology the way we can use it to our advantage. Whereas sometimes before that, you're in a set of scrambling. You're just trying to run through this, work through this. So we can't blame the pandemic for work-life imbalance, blurred lines, all of those things, but it's definitely pushed it along to where we are here now. And I definitely see this legislation as something that is a positive, because at the end of the day, I think it can lead to clear expectations, which helps every single person within an organization. So that's, I guess, like the last piece that I felt like I wanted to contribute there. I have about a minute for Robert, a minute for Alana, and a minute for Valerie, if there's anything else you want to say before I wrap us up here.
I think you've covered it for us. I don't know, Robert.
Yeah,
That's pretty much all we had to contribute today, but we thank you so much for having us on today and being able to have this discussion. And I think the more that we talk about this, the more, we're able to make progress on it. And I think that's really positive. So thanks for having us.
yes, certainly. Thank you to everybody in the audience. Thank you for tuning in. I enjoyed being part of this program, this presentation. We hope you took something of value. The materials will be distributed afterwards. Look at me, I'm kind of taking the host role here, but thank you very much. And if you do have further questions, we're happy to try to address them if you direct them to us by email.
Thank you so much. And Valerie, any last words?
No, just, thank you for the opportunity. The more we can sort of get the information out there, the more employers and employees can benefit from putting the right policies in place. And, please go to the links that were in the presentation that you're going to get a copy of, because there's a lot of good information there, a lot of resources. You don't necessarily want to have to reinvent things or work too hard to find out the answers. They're all there for you if you look. So hopefully people can take that away. Thank you again.
Okay, great. Thank you so much to our participants, our speakers, everyone, and a special shout out to Paige for keeping us on point and organized today. I would be in trouble with her if I don't remind you about the virtual mining health and safety conference that's set for Wednesday, April 27th. They run a wonderful virtual conference. And so please take a look at that. All the information will make its way to you following the session by tomorrow. All right. Thank you so much. Have a great day, everybody.